What if I told you that a traffic ticket isn't really a criminal charge, it's a commercial offer and you can discharge it the same way you would any other debt? In this video, I'm going to break down how traffic citations function as a negotiable instrument, how the court operates like a debt collector, and how to use commercial law to discharge the obligation without paying the fine. I've studied the UCC trust law and administrative remedies, and I'm here to show you how to respond with remedy and not fear. Now, before we dive into this video, this is not legal advice. This is not financial advice. Make sure to do the proper due diligence before you pretty much use this information. Okay? I don't want you guys to just trust me. I want you guys to go find the information on your own. Okay? Number two, if you're brand new, remember to hit the like button. Remember to hit the subscribe button. Remember to tap in so that you can get this game on a consistent basis. We post Monday through Friday, so make sure that you stay tapped in. Now, the reason why I wanted to talk about this particularly is because I always talk about how your traffic tickets and even a communication with a police officer is very similar to the debt collection process. They fall under the category of a fair debt collection of the Fair Debt Collection Practices Act. So everything that I'll talk about on this channel can apply to them too. So we're going to talk about what a traffic ticket actually is, what is happening behind the scenes, what laws apply to it, the legal merit behind it. We're going to talk about how to communicate back with the police officer, or when it comes to a ticket, how to discharge the instrument and how to enforce it. Okay? So make sure that you guys are sticking around all the way to the end so that you can get all the information needed for this. Okay? Now, again, I won't even tell you guys my true take on paying traffic tickets. Okay? Just be strategic. Okay? Don't put yourself in a situation that can be harmful to you. Make sure you're being smart. Make sure you watch this all the way to the end before you take action. People will do what? Watch this video, hear a part in there, and then immediately say, oh, I can do it, and then just start. But I want you to watch this all the way to the end so I can be completely transparent and tell you the truth behind this. All right? Now, what is a traffic ticket? Okay, a traffic citation, or when you get pulled over and a police officer issues you a traffic ticket, that is considered a commercial instrument, like a bill or invoice. And what we know about a bill or a commercial instrument is that is also considered a asset, a financial asset. Okay. Now, I also want to highlight that your ticket is really issued to your straw man, the debtor side of you, your all caps name. And it's a presumption of a contract, not a verified claim. So it's really a contract that they are giving to you. And we typically fall under the jurisdiction when we accept the contract and sign it as if we owe a bill. Okay. But what the ticket actually creates is an offer to contract, whether it's a fine or a court appearance. And the commercial liability is presumed unless it is rebutted. And so I say all this to say tickets can also be challenged as well, because if it's a contract, then it falls under contract law. And if it falls under contract law, then the contract is something that can be challenged. Okay? Now, here are the legal foundations behind this here. So some of the legal merit as it pertains to the validation of debt, or as it pertains to tickets, is number one is the aspect of you being able to challenge the debt. Okay, the police officer becomes a debt collector. Okay, when they give you a ticket, they become a debt collector attempting to collect on a debt. Okay, so it falls under the Fair Debt Collection Practices Act. Now, under the Fair Debt Collection Practices Act, you have a right to validate debts under 15 U.S.C. 1692G. You have a right to challenge debt. And again, obviously, if they violate any of the FDCPA, then they'll be under civil liability. This goes for a police officer. Okay? But then we also can go to E3-104, which breaks down what a negotiable instrument is. A negotiable instrument means an unconditional promise or order to pay a fixed amount of money. Okay? Which your ticket is now a negotiable instrument. Okay? And then we can go to the aspect of UCC 3-603, which is the tender of payment. And it says if a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce and the tender is refused, then there is discharge. Okay? And I'll tie back to this in a second. But what I want to lay out is the fact that they'll treat it like law, but it's really commerce disguised as authority. Okay. You think that it's about, oh, you are required by law to pay this bill, but it's not even that. It's commerce, and commerce is not law in a sense. There's regulations as it pertains. It's almost saying like you are required by law to pay a debt, when it's not even like a law thing, it's contracts. Okay. It falls under contract law. All right. Commerce law and contract law is regulated. Okay. So you have a right to dispute anything within 30 days. So if it's a debt or whatever the case may be, or you owe and it will be considered the court, you'll be owing the court, then you have a right to dispute it within 30 days. Okay. If you decide to, when we talk about accepting it for value and they do not accept it, then the refusal discharges the obligation. And then just understanding the aspect of what a negotiable instrument is going to help enhance the process itself. Okay. So when you do get this letter, when you do get a ticket from a police officer, you can sit there and you can fight and you can say, hey, I won't accept. You can do all this rigmarole. But what I would do is just take the ticket, okay, and keep it moving, right? Take the ticket and keep it moving. But what you're going to do is not going to be fight with that police officer and say, I don't consent, this, that, and the third. No, you are just going to proceed to step one. Instead of ignoring the ticket, instead of arguing with the police officer, you're going to start to communicate with them via written form, okay? How you're going to communicate with them via written form is through what's called conditional acceptance, saying, hey, I accept your offer to pay upon these proof of claims. So you're going to ask them for the proof of contract. You're going to ask them for a sworn affidavit of injury or claim. Okay. You're going to ask for the copy of the bond or oath of officer. And any public official or any public servant or whatever the case may be takes an oath. Debt collectors also take an oath as well. And asking for these things is harmless, right? You're not doing anything. You're not saying you didn't do nothing. You are just asking to see if what they just gave you is a valid contract. And how do they do that? Is by providing that proof of contract. How they do that is providing, if you're saying that that I owe a ticket or whatever the case may be, not because of something that I did, I need to know how I harmed or injured. Who is the injured party? Okay. And the oath of the officer is to know that that officer is complying and upholding his oath or her oath. All right. You want to send this via certified mail with a return receipt, and you want to include any affidavit of truth or what's called a notice of liability. Okay. Because once you conditionally accept, the burden of proof is on them to prove it's not a debt, but a lawful obligation. If it's a lawful obligation, then what happens is, so once you respond or ask them for the lawful obligation with conditional acceptance, instead of just ignoring it or just pleading guilty, you just really are flipping the legal positioning by saying, hey, look, I'm willing to comply, but only if you can prove what I'm truly obligated to. Okay. You're treating the ticket more on the commercial side and not something criminal, because they'll try to make it seem like it's something criminal. But here's what it really means. A traffic ticket is presented to you as if it's a mandatory obligation. Mandatory meaning that you have to do it, whether it's a fine, court date, points, whatever the case may be. But in commercial law, every claim must be supported with evidence: a signed contract, a verified injured party, lawful jurisdiction. And when you conditionally accept, you're lawfully saying, I accept your offer to pay or appear upon proof that I am lawfully required to. Okay. It's powerful because when you respond in this way, you don't default into guilt like most people by ignoring. Number two, you place the burden of proof onto them. And number three, you stay in honor. And if they don't prove the obligation, then the matter becomes dishonored, and you may be able to enforce the remedy based on their non-response. So if you receive a $200 ticket and respond, I accept upon proof of that a valid contract exists, and that you have authority over me, and that a party was injured, now the officer, court, or prosecutor must prove those things. And if they don't respond, or if they can't prove it, then they fall into commercial dishonor, which you can document and use as evidence. So thinking about it from an aspect of, a lot of times people think it's about the debt, but when you start to bring up these claims and these challenges, then now they have a performance to meet as well. So this is the reason why when it comes to debt discharge, a lot of people think that it's about, putting some magic word or whatever the case may be, but these questions alone is what now puts them in a position of where they have to provide the proofs to you, okay? You're saying I agreed to pay, then why don't you just show me the proofs, right? If you are a true injured party, if there's a true obligation, right? And, this is not the time to argue that an obligation is also something that is considered as security as well, that they would just monetize. But that's besides the point, okay? So when you take them through this administrative process, this is the reason why you are doing it, okay? To shift that positioning, okay? The next thing you want to do is start the discharge process of the instrument, okay? You can use one or more of the following. Number one, you can take that ticket, the original ticket, and mark it as accepted for value, okay? Which is very similar to the coupon process, and you can endorse it the same way as a coupon or whatever the case may be. As a matter of fact, I won't even put that out there, but if you put that you accepted it for value and then you pair it with a notice of acceptance letter, now you're pretty much like, you're now turning that into a negotiable instrument under UCC 3-104, okay? Number two, another thing you can do is you can issue a promissory note or a bonded instrument if you are in a secure status or you decide to do it through a trust, okay? You can also attach forms like IRS 1099As and a Form 56 if you're doing it through a trust. And you can include UCC references and a notice of private administrative process, okay? You can do the private administrative process without the trust, but if you're going to do it without the trust, then I would do it with the accepted for value version. And again, this is not going to immediately discharge an obligation, but you are now tendering a performance, okay? A performance to meet an obligation. So if you create a performance to meet an obligation or a negotiable instrument and you send it to the party and they refuse it, then UCC 3-603 discharges the obligation, okay? 3-603, when you put accepted for value, you just created a negotiable instrument and your negotiable instrument falls under a contract, okay? Principles of law applicable of tender of payment under a simple contract, okay? And any more of this section, okay? And I'll put those up there. Some of you guys may have seen it before, but to know how this applies to this particular situation, all right? It's important to include your time frames for a response. So if you say, hey, you have 14 days to respond, 10 days to respond, 30 days to respond, then you are you're being very specific of how much time that they have and what's going to happen after they don't respond or if they decide to ignore it or whatever the case may be. You want to document everything, your mailing receipts, affidavits, and timelines. Typically what happens is you're going to have to present this evidence in court. You may show up in court. This is not taking you away from going to court. You may potentially still go to court, okay? But instead of you going to court and contesting what happened with having them prove whether you actually ran the red light, drove crazy, tagged, whatever the case may be, you're actually coming with evidence of where you're challenging them on the contract that they are attempting to form with you. Because it doesn't really matter what you did if they just created a unenforceable contract, okay? Now, the court may ignore you, but if they do that, then it pretty much, they'll fall in dishonor, okay? Step 3, you want to enforce the dishonor. So if they do dishonor you, this is when you dive into notice of fault and the opportunity to cure. Okay, this is a part of the administrative process. You sending a negotiable instrument, you send a negotiable instrument, they don't comply or they ignore, whatever the case may be, you send them a notice of fault. You say, hey, look, I noticed that you guys didn't respond. I asked for particular proofs and you decided to ignore it. And because of that, I'm giving you an opportunity to cure. I could go and say, you know what, you are in full dishonor, but I'm giving you an opportunity to cure. That's you moving in honor. That is how you're supposed to do that. Why don't they treat you the same way? Because they want to dishonor you. They really don't care about being honorable. Okay? So you giving them a second opportunity is you just saying, hey, look, there you go. There's your second opportunity. Maybe you missed it. But if after your 2 attempts of asking for these proofs that they are required to give you and they don't respond properly, then that's when you dive into a default. Okay? When they default, then pretty much everything that has happened up until that point stands in truth, and that is them literally breaching a contract. When you breach a contract, then that's typically when you default. Okay? So if they continue to not respond, then you send a certificate of non-response, and that certificate of non-response is going to lay out how they did not respond and they acquiesce to everything. Okay, because their silence is acquiesce, and typically they will be silent. And yes, you may not get an immediate response right there, but when you do pull up to court, if you pull up to court with this document, this is going to give you a better contest against the ticket. If you can walk in there and literally challenge that police officer on a ticket, even providing any level of evidence, is going to put you in an even better position against that ticket. Okay, and someone will say, well, it's no point in me doing all of this for $100 or whatever the case may be. I agree. Some people get $300 or $400 or $500 tickets, whatever the case may be. Or some people just don't want to go to court. And this may be able to prevent that, but I wouldn't even like expect not to go to court by sending this. Okay. A lot of times people are afraid when they get pulled over, or they might get a ticket or whatever the case may be, or maybe even try to do things like fight the police officer and challenge the police officer. And even that, if there is any other level of harassment that you have gotten, this is something that you can also include in your documentation. Okay? Depending on how you interacted with the police officer. Okay? But you would use this dishonor to do things like file a lien. I'll be very strategic. You want to be in a secure status in order to file a lien using the UCC1. You really want to use this to present your evidence in court to be able to challenge that contract or challenge the ticket, push for a dismissal of the case. Hey, look, I understand that they wrote this ticket to me, but I never consented to it, and I asked them to provide proofs that we are even in a true obligation or contract. They didn't provide that. The judge can say, well, I mean, you were doing this and you're doing that. No, well, I get that's what you're saying I did, but I mean, I'm challenging the contract itself, okay? Because there is no injured party, and that's what I'm talking about. What am I doing here if there's no injured party? Who was injured? Okay. And then now you reassign that liability to the court and the officer. Straight up. Because you have to provide these proofs in order for me to even continue. Okay? Because I've created that paper trail. Now that I've created that paper trail, I now have that leverage. So another thing I wanted to cover is what to say when you are in this particular situation, like what that real life situation could possibly look like, how to respond so that you don't be held in contempt, possibly get put away or be arrested for saying the wrong things. I do say not to argue with them. It's best that you are calm and respectful, right? You treat them like a human being, and do your best to not escalate, or making sure that you are firm in asserting your rights and putting yourself in a position where you aren't affected negatively. So as long as you be calm and respectful, this is exactly how you can communicate with that police officer. Okay. And I'll include this script in my school community. I'll go back, review this video, put together a script so that you guys can be able to see it. You'll have to be a part of the school community. But also for my people, I'm about to put y'all onto some game right now. So if you've gotten this far, please hit the like button. Go ahead and hit the subscribe button if you're brand new, so that because I mean, you've gotten this far, if you gathered any type of game, just hit the like button, hit the subscribe button if you're brand new. Okay. So here's what you want to say. You want to say, good evening, officer. I'm traveling peacefully, and I'd like to keep this stop safe and respectful for the both of us. It's important you disarm the tension and set the tone as a peaceful, law-abiding citizen, not an aggressive person, but you are aware, okay? Some people in some of the videos we see, people are angry, mad, or whatever the case may be, but the people that are able to truly get by are the ones who are very calm and collected and respectful, okay? Those videos of people raging out on the police officer, screaming, or whatever the case may be, you don't want to maneuver like that, especially if you don't want to be harmed, okay? Because a lot of times people do that. They get in a situation and their process or their fight gets delayed. The police officer may violate their rights or whatever the case may be, but they'll push that case as long as they can, okay? Another thing we want to do is not to admit liability. So if they ask, do you know why I stopped you? You never tell them. You say, I'm not sure, officer, but I'd like to reserve my rights before making any statements. Okay. This avoids self-incrimination and prevents them from using your words as evidence. Okay. You want to also assert your rights without creating conflict. You want to be calm and say, for the record, I'm a private traveler, not engaged in commerce. Am I under custodial arrest or am I free to go? This signals that you understand the difference between traveling privately or driving commercially. Most traffic codes apply to commercial activity, not private travel, and the courts have recognized this as a distinction in certain contexts, okay? They also, if they do things like ask for your documents or IDs, right? To avoid escalation, I would just comply, but preserve your legal rights in writings or verbally. And this is what we'll do in a conditional acceptance, but you can also say this out loud. If they have the body cam or whatever the case may be, hey, I'm presenting this under threat, duress, and coercion. I do not consent, and I reserve all my rights under UCC 1-308. Okay? Before they write the ticket, say, officer, if there is no injured party and no verified claim, remember I'm staying consistent, I'd like to resolve this matter privately without contracting with the court. Would you be willing to issue a warning today? This positions you as someone who knows the difference between a civil enforcement and a lawful injury, and it shows that you're open to a peaceful resolution. Okay? Here's what you don't want to do. You don't want to argue, raise your voice, or cite random YouTube laws. Okay? Don't claim diplomatic immunity or refuse all communication. Don't bring up the sovereignty conversation. You know what I mean? Oh, my status is corrected, even if it is, because it doesn't matter at that point in time. You just need to get out of that situation so that you can be able to be safe. And you can remember, you can take this entire argument on paper and offline and privately. And you don't want to obstruct or get out the car unless asked. Okay? Here's a bonus strategy. Is to film. Okay, this recording is for my protection and yours. I do not consent to a search, and I'm complying under protest and reserve all my rights under UCC 1-308. Now, some of the legal merit behind this, more to cite my sources, what I've kind of reviewed, are as followed. Okay, the first thing we'll talk about is the aspect of the case law, which is it's a couple case law that we can talk about. Shipero versus Thompson. Shipero versus Thompson pretty much talks about how the right to travel is a fundamental is a fundamental right, and it's also protected by the Constitution. If they try to limit your right to travel, then that will be considered something to be unconstitutional. We can also go to Kent versus Dulles, 357 U.S. 116, 1958, where it talks about the right to travel is being a part of the liberty of which no citizen can be deprived of without due process. Freedom of movement is a basic value that we should have, okay? It's also useful when you are challenging the jurisdiction or claim when you are traveling privately and not commercially. We can also go to Title 49 CFR 392.2, which applies to commercial drivers, which talks about how a federal motor carrier rules applies to only commercial drivers and not private travelers. So when you put that distinction that you are a private traveler, simply asking the question, am I being charged as a commercial driver engaged in interstate commerce? Now, this can also get very tricky because when you do, register your vehicle with the state, technically it's a motor vehicle, and technically the motor vehicle could be considered commercial. So, throwing this out there, it may be helpful. but sometimes they may try to debunk that and turn you into a commercial driver. You can also understand 42 USC 1983, which talks about civil action for deprivation of your rights, allows you to sue government officials for violating your rights under the color of state law. So again, you have the ability to even challenge the police officer and sue them. Not saying it's going to be easy, but you can. All right. Also under 18 USC code 242, which is more of like that counter part to 42 USC 1983, essentially saying that it's a crime for any person acting under the color of law, such as police, to willfully deprive someone of their rights protected by the Constitution and the U.S. law. This is a really good one because you can use this to remind those public officials that they are personally liable if they violate your rights without due process. This also dives into the like Miranda versus Arizona, which talks about you having to be Mirandized, especially if they're about to arrest you and things in that nature. If they do anything to deprive you of your rights or do anything without your consent, 18 USC 242 pretty much holds them accountable. And then this goes hand in hand with 18 USC 241, which is conspiracy against your rights, which is pretty much in its name itself. It's a federal crime for two or more persons, including the police, to conspire to injure, oppress, threaten, or intimidate anyone in the free exercise of their constitutional rights. And this matters because if an officer threatens you into waiving your rights or falsely applies commercial codes to private activity, then this can be considered a level of conspiracy. And then also, obviously UCC 1-308 is your reservation of rights. Okay, so you have a right to reserve your rights. A party that performs with explicit reservation of rights, it does not lose its rights. Okay, and a lot of times our rights are lost because we are immediately assumed to be a debtor. Okay, so saying things like I reserve my rights under UCC 1-308, I'm presenting this under threat, duress, and coercion for the record. All right, this is important and a better statement, right, to say at the stop, or will be something like this: Officer, I'm traveling peacefully, okay? And I wish to remain an offer. I do not waive any rights. I reserve all rights under UCC 1-308. I'm not engaged in commerce. And I respectfully ask, is there any injured party or verified claim of harm? If pressed further, you can say, I do not consent to a search or contract. Any action taken against my rights without due process may constitute a violation of 18 USC 241 and 242. Okay, I know it's a lot to pretty much cover. I didn't want to overload you guys with too much information today. This will be more of a part one. Let me know if you guys want to learn a little bit more about this. Want me to dive deeper into traffic tickets, communicating with police officers in a more legal merit type of framework. Also, how to be able to hold them accountable, shift the burden of proof in written form. My methods is always going to be do things in written form. Communicating with them in front is just a bonus. If they will be respectful and they will be honorable, then the communication up front may work. But if it doesn't, always be willing to take them to the written form. Always be ready to take them to the private side, okay? Because traffic tickets are commercial by nature, and you can treat it as such, okay? So if it's commercial, then it can be discharged, okay? Stop thinking like a defendant and start moving as if you are the creditor, okay? Start moving as if they are a public servant, all right? You don't disrespect them or do anything that maybe make it escalate, but you have some ways to assert yourself and you have some rights. All right, so what I would do is take a look at those laws, gather the information as much as possible. I'm going to put together a script, throw it in my school community. My school community is less than $1 a day. Tap into the school community. The link will be in the description. Number two, if you want to get tapped into my live streams, the Discord is also down in the description as well. If you want to work with me one-on-one, specifically with your credit, specifically with getting funded, or even you want to sit down and have a conversation with me about your documents, whatever the case may be, you can go ahead and book that one-on-one mentorship call. Lastly, If you ever received a ticket and wanted to fight it and you tried discharging it before, let me know your experience down in the comment section down below. Remember to hit the like button, remember to hit the subscribe button, turn on the post notifications so that you get an update every time I post a video. I love you guys. If you've gotten this far, comment the word discharge, and I'll see you in the next one.